Good morning, Dan Alasso with History for Today. And this morning I would like to talk a little bit about copyright and Creative Commons because I'm going back into another OER learning circle with my Minnesota State University colleagues. And the leader of the circle asked me to contribute to my video that I had made for the Creative Commons certification course, and somehow I've managed to lose it. So I'm going to start at the beginning and do it again. So, copyright. Copyright itself was first enacted in 1710 by the British Parliament in an act called the Statute of Anne, which was named after Queen Anne, which begins like this. It says, "Whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing, reprinting, and publishing, or causing to be printed, reprinted, and published books and other writings without the consent of the authors and proprietors of such books and writings, to their very great detriment," meaning to the great detriment of the authors and publishers, "and too often to the ruin of them and their families. For preventing, therefore, such practices for the future, and for the encouragement of learned men to compose and write useful books, may it please your majesty that it be enacted," blah, 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 yada, yada, yada. Queen Anne was the sister of Queen Mary, the daughter of King James II, who had been deposed in the Glorious Revolution of 1688. Mary and her husband, William of Orange, took the throne, and after they were both dead in 1702, Anne took the throne. She ruled for 12 years, and then the throne passed to her second cousin, George I, a 54-year-old German ruler of the Duchy of Hanover. Anne had 50 closer relatives, but unfortunately they were all Catholics. In any case, the Statute of Anne specified a copyright period of 14 years, and it allowed copyrights to be renewed for a similar term. The statute also, for the first time, vested the copyright in the authors rather than in the publishers, which was an important and significant change, and very good for authors. Any creative works or performances can be covered by copyright as soon as they're performed or recorded. The ideas in the work itself are not protected. There are other forms, such as trademarks for commercial expression and patents for inventions that cover ideas that their creators want to protect as intellectual property. In the US and under the Berne Convention, copyright begins as soon as the person creates the work or performs it and doesn't need to be applied for. However, registered copyrights can be easier to protect since the registration establishes a paper trail and what might be called a chain of custody. The Berne Convention for the Protection of Literary and Artistic Works is an international agreement established in 1886 and originally signed by 10 nations. Currently, there are 176 states that are parties to this convention. Some of its minimum standards include that the term of the copyright must be at least the author's life plus 50 years. And that copyright must be automatic and that formal registration is not required. Interestingly, the United States did not sign on until 1989, partly because this convention nullified America's requirements for copyright registration and mandatory copyright notice. Under the Berne Convention, a person receives a copyright as soon as she creates a work in recorded form or in a performance. This is unlike other forms of intellectual property, as I said, like inventions that must be protected by filing for a patent. At the end of the copyright period, the work enters the public domain and it becomes available for free use and copying and modification. Anything made by the government or made by a government employee in the performance of his job also automatically goes into the public domain. So there is a good deal of information in the public domain in addition to things that authors have donated and that have gone out of copyright. Works that are made using this public domain material would then also be covered by copyright, but the copyright wouldn't extend to the public domain elements that are incorporated into the new work. Copyright extensions and limitations are designed to safeguard the public by allowing people to use excerpts of works for the purposes of scholarship or review or commentary. Works that couldn't be quoted also couldn't be reviewed or discussed in a public forum. Similarly, educators are allowed to use works in classroom settings under what are called fair use provisions, without permission and without payment. Also, once a single copy of a work, say a book, has been sold, it can be resold, donated, loaned, or otherwise passed on to anyone without additional permissions or payments to the copyright holder. This is what allows libraries to loan out books, of course. The advent of ebooks has muddied these waters a little bit, since technology has to be developed to prevent the loaned copies from being kept, which would be copying rather than lending and would violate the copyright. Many of the digital rights management systems that people have tried to implement to deal with these issues are controversial and have been criticized by advocates of information sharing. Now, what is Creative Commons and why does it matter? Who came up with it and what does it do for creative people and for folks who'd like to use the things that creators have made to do things like teach? So I dug into this quite a bit while I was taking this Creative Commons certification course as a way of learning more about OER, Open Educational Resources, in preparation for developing my own OER content for my courses at Bemidji State University. I was familiar with Creative Commons as a license format that for the last several years has allowed me to use images that I found online on sites like Wikipedia for my lectures, in my American Environmental History videos, and in my textbook. You can also use out-of-copyright material from old books, which you can typically get off of places like archive.org, and sometimes even videos. But there really isn't as much material out there as there should be, because so much of it is locked up under these all rights reserved copyright licenses. And again, historically, these copyright licenses were enacted to prevent people from stealing the work of authors and publishing unauthorized copies of books. In colonial America and in the early Republic, printers like Isaiah Thomas of Worcester, whose actual printing press is on display at the American Antiquarian Society, which Thomas founded in 1812, he made a lot of money by publishing not only the works of American authors, but by reprinting British and European works that weren't adequately covered by functioning international copyright laws. While this wasn't particularly fair to the British authors, it did allow a lot more Americans to get their hands on inexpensive copies of important literary and scientific titles. And this may have helped spread knowledge in the early 19th century. It may explain the uncanny number of children named after Erasmus Darwin in Massachusetts in the first decades of the 1800s, which is another story that I've told elsewhere. But not everybody has been happy with this idea that information just wanted to be free. Before skiing into a tree in January of 1998, Sonny Bono was one of the 12 sponsors of a bill in the U.S. House of Representatives to extend the period of copyright for an additional 20 years. As a result of that, old creative works, such as books and films, are now protected for much longer than they once were, although not forever, as Sonny Bono had hoped they would be. It's interesting that although the Constitution originally sought to, quote, promote the progress of science and useful arts with both copyright and patent protections for creators, the term of patents is still only 20 years. Apparently, inventors didn't have quite as much political juice as the Disney company, which was anxious to prevent Mickey Mouse's first movie from entering the public domain. Copyright, which had originally been intended to give people proper credit and compensation for their work, now seems to serve media conglomerates and restrict access to content, especially in the digital world. Lawrence Lessing, a founder of the Creative Commons movement, challenged the Bono copyright extension law in Eldred versus Ashcroft, but he lost in a 7-2 decision of the Supreme Court in 2003. And things got even worse in 2012 when another Supreme Court decision, Golan versus Holder, allowed copyright extensions to be reapplied to works that had already shifted into the public domain, causing millions of works that had come out of copyright to go back into copyright and be unavailable for free use. Some people may find it ironic that Bill Clinton signed the Bono bill into law and that the Obama administration led the fight to re-copyright public domain titles. Lessig was a Harvard Law professor founded the Creative Commons organization and was CEO and chairman from 2001 to 2007. He remained on the board until 2013. The Creative Commons organization publishes international licenses for Creative Commons attribution, and it advocates for sharing and for making knowledge more accessible worldwide. The organization manages an affiliate network of over 500 organizations in 85 countries addressing intellectual property issues in a variety of social and cultural environments. Over 1.3 billion works are now licensed using Creative Commons. License types range from CC0, which is the public domain basically and reserves no rights for the creator, through CC BY, which requires attribution, so you have to say who the author was, and BY-SA, which is attribution and share alike, and that specifies that people not only have to name the source, but also have to license their work in a similar way, so that it will similarly be open. Further restrictions are available, which can specify that subsequent works will be NC or non-commercial, that the reuser will not alter the work in any way, and also that it can be required in the SA format that any of these additional stipulations can be required of the next work that wants to use the licensed material. So generally, I think it's fair to say that Creative Commons licensing gives us a more democratic way to use intellectual property, while still preserving some of the rights of people to the product of their creative work. So I hope that was helpful. Thanks for listening. I'll see you again next time.